Hello, my name is Kerry Peck. I lead the law firm of Peck Ritchie with primary offices in Chicago. Today I'm going to talk about temporary guardianship. A temporary guardianship is necessary in circumstances involving often emergency surgery, financial exploitation, and cases that require a third-party decision maker appointed by the court on an exigent basis. So, for example, my office frequently appoints and seeks the appointment of a temporary guardian when an older adult is financially exploited. Perhaps a caregiver is taking advantage of an older adult, and we go into the probate court and file for temporary guardianship. Now, it's imperative that you know that in order to file a temporary guardianship, which is a short-term appointment of a third-party decision maker, as well as filing for the appointment of a plenary guardian, which is a long-term appointment of a third-party decision maker, it's necessary that both of those procedures rely upon a medical report. That medical report in the Circuit Court of Cook County is called a CCP 211. And throughout the state, it's required by statute, and certainly I'm confident the form numbers are different county to county. But before you undertake the representation of a family or an individual who wants to seek the appointment of a guardian, you must make sure that they are able to produce for you and the court a medical report which indicates that the alleged disabled person, that's the person whom a guardian is being sought for, is totally incapable of making either personal and or financial decisions. So guardianships come in a variety of different types. We've talked about temporary, we've talked about plenary, but guardians also come exclusively in the following fashion: a temporary guardian of the estate, which is the management of property or other assets, or a temporary guardian of the person. So let's use a hypothetical example. A family comes to you and asks you to get involved in the representation of the family because the alleged disabled person, a patient in a local hospital, has refused to consent to the amputation of a gangrenous leg. That individual certainly has the ability to refuse to have that leg amputated, assuming they have the mental capacity to make that decision. Frequently in the medical circles, decision-making capacity is deemed to be, this patient in our hypothetical is non-decisional. So in the medical community, the terminology non-decisional is often used. In the legal community, one frequently hears the terminology mental incapacity. In any case, both of those terms mean someone who suffers from a cognitive impairment. That impairment may be the result of a temporary circumstance, perhaps a stroke in which an individual is recovered, perhaps a traumatic brain injury from an automobile or motorcycle accident, or that circumstance could be they are no longer able to make decisions because of a long-term circumstance. Perhaps the stroke has eliminated their ability to make decisions, or a brain traumatic injury eliminates long-term their ability to make decisions. So step one in this process, after of course you're engaged by the client and the family, is to consult with the physician that is going to write the medical report. And again, statutorily, that medical report must unequivocally state that the alleged disabled person, the person for whom you are seeking a temporary guardian, is totally incapable of making personal, which is medical, and or financial decisions, which is the management of their property and their assets. Once you have a medical report that lays out the statutory language, which can easily be found in the Illinois Probate Act, You then file the case certainly in the Circuit Court of Cook County. We file it in the probate division. Likewise, in all counties here in Illinois, there is generally a probate judge assigned to hear guardianship cases. But the law requires that when you file for temporary guardianship, you must also file for plenary guardianship. During the guardianship process, the statute requires that the court appoint a guardian ad litem to go and visit the alleged disabled person. Those visits can occur in a hospital, a nursing home, or if the individual resides in their own home or someone else's home, the guardian ad litem literally will get in their car and go see the alleged disabled person. This is regardless of whether the medical report relates that the alleged disabled person does not have decision-making capacity, and certainly in circumstances in which the alleged disabled person may even be unconscious. So a guardian ad litem is an attorney appointed by the court. Typically, the judges refer to the guardian ad litem as the eyes and ears of the court. That guardian ad litem is duty-bound to inform the alleged disabled person of their probate rights under the Illinois Probate Code. I call them the probate Miranda rights. We frequently see on TV where a criminal in a cop show is wrestled to the ground and handcuffed, and the cops say you have the right to remain silent, you have the right to a lawyer, etc., etc. In a temporary guardianship case, the alleged disabled person is given their probate rights. They include the right to a lawyer, the right to consent or oppose the appointment of a temporary guardian, the right to another medical exam, the right to a jury trial, the right to appear in court. So these are very, very, very substantial rights that the court typically protects in a very judicious fashion, because the result of a guardianship is the loss of significant civil liberties. After a temporary guardian is appointed, typically a plenary guardian will be appointed, and most individuals will lose the right to drive and lose the right to vote, to name a few of very significant civil liberties that are taken away in, again, this civil probate proceeding. We lawyers are accustomed to the loss of civil liberties in criminal cases, but in a probate case, the alleged disabled person, who at the end of the process will be deemed to be a disabled person, is subject to losing many civil liberties, some of what I've just enumerated. So the guardian ad litem will go out, visit the alleged disabled person, advise them of their probate rights. That's one of their duties. And the second duty that a guardian ad litem performs is to basically perform a mini mental status exam upon the alleged disabled person and find out if they can engage in conversation, if they're oriented to time, to place, to person. Do they know, for example, who the President of the United States is? Do they know the mayor of Chicago? Do they know the date, the month, the year? And how is their orientation in the context of understanding the process they are facing, or not understanding the process they're facing and not capable of consenting to, in our hypothetical, the amputation of a gangrenous limb? The guardian ad litem in a temporary guardianship most of the time will file a report orally with the court. A temporary guardianship case is heard very quickly in the Circuit Court of Cook County, typically within about 2 to 3 business days from filing to the first court appearance passes, and the guardian ad litem will go out and come back to the court and report orally and sometimes in writing as to his or her findings and recommendation to the court. The guardian ad litem is also duty-bound to ask the alleged disabled person if they consent to the appointment of John Doe as guardian, and or if they oppose the appointment of John Doe as guardian. Very significant question asked by the guardian ad litem and reported to the court. So on the day of the court proceeding, the guardian ad litem will report to the court. You as counsel for the petitioner will appear in court. The alleged disabled person, if they wish, is entitled to appear in court. The court will examine quite closely the medical report, hear the report of the guardian ad litem, and make a decision as to whether a temporary guardian should be appointed as a result of the exigent circumstances in our hypothetical, again, the proposed amputation of a gangrenous limb. If the court concludes a temporary guardian is necessary, the court will appoint a temporary guardian, require a surety bond if it's for guardianship of the estate, and the court will reset the matter over for a plenary hearing. If it's for temporary guardianship of the person, in our hypothetical for the amputation of a limb, the court will enter a specific order granting authority of the guardian, the temporary guardian, to authorize the surgery. It's important to know that temporary guardianships expire 60 days after the order is entered, and typically the courts appoint a temporary guardian only one more time. So it's very important that you watch the clock on a temporary guardianship and get into court in a timely fashion, if necessary, to extend the guardianship either as temporary or proceed for the appointment of a plenary guardian. For more information on temporary guardianship, an elder law attorney's tool for protecting clients from financial exploitation, please view my full presentation recorded during the Guardianship Bootcamp 2015 and available in the ISBA Online CLE archives.